Good evening. Every Tuesday, we do bring in immigration updates from Reddy Neumann, and we've been doing this for almost a decade. And we take live questions from 5 to 6. Emily, what do we have today to discuss?
Today, we want to talk about the new $15,000 visa bond rule. It's been talked a lot about in the media as a new proposal or really final regulation issued by the Trump administration that makes it sound like people have to pay 5, 10, or $15,000 to get a visa at a consulate. So we'll talk about who it actually impacts, how big of a deal this is, how long it lasts, and what is the likelihood of it being expanded further. We'll also update on the visa stamping interview requirement. It will be mandatory for almost everybody beginning September 2nd. What is that going to look like? Do we expect more visa slots to be opened up? How does that work for kids and senior citizens? And then we find a common issue where people are on a non-immigrant status like an H-1B. They also have a pending 485 with an EAD and advanced parole. And what do they do in a job loss situation? Is it best for them to do what they can to continue the H-1B status and file a transfer within 60 days, or file a change of status to B2 or H4 to continue their non-immigrant status? Or is it safe to just use the EAD and the advanced parole and abandon that non-immigrant status going forward? And then lastly, we're hearing a lot about people taking a medical leave while they're on H-1B. So we'll talk about, is that a good idea, or is it better to switch to H4 or B2 or some other type of visa category when you're having difficulty with your employment and have the option of using some sort of long-term medical leave instead?
First thing, Emily, it's been proportionately said that everybody on the B2 needs to pay this 15,000. How truthful is this?
Zero truth to it. In the rule itself, so it's a pilot program, first of all. It lasts for 1 year. It's started already and it goes through August 2026. There are specific countries that are part of the pilot program. And in the rule itself, it says how many people this is expected to affect. And it says 2,000 total. So they're expecting about 2,000 people over the next year to have to pay this $10,000 bond. Now, the rule itself gives an option to the officer to give 5,000, 10,000, or 15,000, but the standard is likely to be 10,000 according to the language of that policy. And then, so for people from, oh gosh, Zimbabwe and Malawi, I think are the two countries that they announced earlier today. Not everyone's going to be subject to this, maybe up, because those countries usually give about 2,000 visitor visas total each. So maybe half of the people might be impacted by this. They have to pay this, and then they only get a 3-month visa. They only can enter at certain airports, and then once they come back and prove that they did not work without authorization, they came back timely and all those things, they will supposedly get their money back. But again, it's only expected to impact 2,000 people. It doesn't impact all business visas. Tiniest percentage of people will be impacted by this. Now, could it be expanded after a year? Potentially. I think that depends on whether they feel that it's working to somehow reduce the overstay rate for these countries. I think in reality, it's just going to cause people to not apply for the visa. I mean, who's going to pay $10,000 just to come to visit for 3 months? I think that's very unlikely for that most people in these countries are going to be able to afford. So it's more like just another way that the Trump administration can build this invisible wall to keep people from coming into the US lawfully. So not too much to be concerned about in my book.
And it's been over proportionately, but mostly it's not applicable to the Indian nationals, so I don't think so. They should be worried about it though. And it's not for those people who already got the visas. If they are visiting, do they need to shell the 50,000 at the airport? The answer is no. You don't have to. Um, Visa stamping is now mandatory after September 2nd, where visa interview is now mandatory for the people. What is expected right now? We definitely tell people that don't go for visa stamping if you are in United States, and if you're planning to go, make sure you consult an immigration lawyer. Make sure you make an alternative plans if you will your job keep extending. If they do issue a 221G and they're going to keep you for extended period of time there, only to make you lose the job. I also want to point it out that recently Trump administration, when they came in, did fired about 40 to 50 immigration judges. Of course, these are people appointed by the administration. They can be fired by the administration. They did fire some people, and we have seen Department of Labor recently did announce that there are some unemployed people that number increased. So Trump administration fired that person. Now, if you feel that Trump administration is favoring immigrants and wanting the non-immigrant visa people, especially the work visa people, to come into United States, I will say best of luck to you. I can't explain how intelligent you are. I can tell one thing is that the Trump administration is also going to fire the people who are issuing the visas. Simply that. I mean, look at it, how the Trump administration is behaving. I don't, I cannot confirm it's happening right now. I'm sure if officer feels that everything is all right, consulting company, that's fine. There is a vendor there, that's fine. According to regulation, everything feels good. This is a genuine job, and that guy keeps on approving the H-1Bs without issuing a 221G. I'm sure he's going to get fired in this administration. So if you feel that Trump administration is in favor of working visas, want you to come here, work, and make money, then it's up to you to go for stamping. I've had a lot of situations. My 50% of my consultations right now, or at least 40% of my consultations right now, are people getting stuck there. There are people trying to go to stamping, and which I keep begging them, please don't go, don't go. That's how the situation is right now. Now, for the people who are attending the visa interview in where they have to, I mean, if they are in India, they got the H-1B, and if they're an F1 and they're attending the visa, please make sure you be very thorough with what exactly your purpose for you to come into United States is. If it's an H-1B or L1, please make sure that you read the H-1B or L1 petition so that you can understand the job duties, the job you're doing. If you feel that there is any discrepancy, call the employer, call the employer's lawyer. It's always good to argue with the employer. It's always good to argue with the employer's lawyer because they won't harm you. At least I can say the employer's lawyer will not harm you for sure. He will try to convince you something, but he will not just harm you. He will not harm his company. Any employer's lawyer, I guarantee that for you. Please argue or debate with your employer's lawyer, no problem with it, but don't go to the consulate with it preparing. The consular officer will know where to look into the files, even if it's a 500 pages file. They know where to look into it. They particularly look into the job duties. They look into the LCAs and the H-1B. And they will look into only those 2-3 paragraphs, and they can get a clear idea of what's going on in those things. And if you don't look into the job description very clearly and you're looking into your own education certificate and looking into it, you don't need to look into it. You already know what you got it. So please look into what the employer has submitted the job duties. That's very important. Emily, any tips from your side, and what are you seeing?
Yeah, I mean, we know that there's going to be difficulty in getting visa interview appointments when we now have everybody needing to get an interview, regardless of your applying with the same company that you've been with for 10 years and have gotten 3 visas already in the past, you're going to have to be interviewed again. And so it's going to take longer to get that scheduled. Then, because there's so many people that need to go through an interview, that means the processing time to get the passport back with the visa stamped in it is going to be longer, not counting any potential 221G or administrative processing, which we also expect to increase. As Raul said, this administration, their goal is to deny not approve. And so we would definitely tell you to really consider the purpose of your travel and if it's really worth the risk of being stuck indefinitely outside the US and potentially losing the job because you're not able to come back into the US to take that job. And then, as Raul said, review the petition. Make sure that you have all of your W-2s, your pay statements, bank statements. Everything needs to be aligned with what was specified in the petition. Make sure when you're filling out the DS-160 that you are accurate in providing job titles, job descriptions. I know they only give you a very small box, but a small summary should be aligned with what you're actually doing. Dates of employment. Make sure that you're including all employment, including employment that you may have had during CPT, include all school that you've attended, even if it is a day one CPT school that you maybe didn't actually graduate from. We've seen that be a problem for people. So overall, the recommendation is to not travel if you are inside the US and would require a new visa stamp in order to return. And if you are outside the US and have to come into the US, need the visa stamp, that's just a hurdle that you're going to have to go through, plan on it taking longer, get that interview scheduled as soon as you can.
Right.
All right. So what do you think about, someone who's got their H-1B, they have their 485 pending, EAD, AP, they lose the job on the H-1B. Should they forego H-1B status and just start using the EAD going forward? Or is there some benefit for them to keeping that non-immigrant status?
Emily, I'm a marathon runner, and marathon is a very long run. It's 26 miles and 42 kilometers. I've done that several times. Every weight that we carry on us is a burden for us. I mean, we like to be very light, everything. I mean, of course, if you go on a marathon race, they do give us water, so we take it. So this one, 485 application is also a marathon race. When you're carrying two things in your hand, you are burdening yourself, though. I definitely feel everybody should have an EAD because it's a very light weight. It's easy to get an EAD. You don't have to provide the inclined letter. You don't have to provide the ventilator. You don't have to provide, you don't have to file, for most of the people, for those people who filed the 485 before 2022 or so, where there is no filing fees for 95% of the people that we do. There is no filing fees for it. And for all these good things, though, you get an EAD. And even if the approval doesn't come in, you can work for a period of 180 days. I think so it's 540 days, but even if it goes back, it goes to 180 days. So definitely want everybody to keep the EAD. Now, carrying the H-1B is an optional thing if you have an EAD. I personally, I'm not going to tell people what to do, but I personally, when I was in Adjustment of State Assembly, I did not. I did not have the. I did not have the. Yeah, I did not carry the non-immigrant status. I let it go so that it becomes easier for me to travel. At that point of time, adjustment of status was taking less time. Right now, adjustment of status, especially for those people whose priority date is 2014, and that may take a long time. It's take a call on it. If you have a clean record, you may not want to carry the H-1B though with you. People will ask me questions, Emily, that what happens if the 485 gets denied? Will I be able to be in status? Definitely, if you don't have an H-1B, you will become out of status. Definitely, you may have to go outside the country, but you can go outside the country, get the H-1B stamping and come back. That option is there. There is a little bit hurdle there for you, but there are more hurdles keeping the H-1B. That is my firm belief, Emily.
Yeah, with employment-based 485s for someone who has not had any immigration issues in the past, doesn't have any criminal issues, it's a relatively safe process. And most of them do get approved. I think the number one cause of a 485 denial in the employment-based category is when it's filed concurrently with the I-140 and the I-140 gets denied. So nothing to do with the 485. The 485, you just need to show that you entered the country legally, that you maintained your status from the time of last entry going forward, and that you're not inadmissible for any reason, which is unlawful presence, work without authorization is an inadmissibility, but it can make you not eligible for adjustment of status if you haven't cured that issue. There's many people that rely on the 485, forego the H1, forego the L1, and successfully receive the green card without any issues. Yes, there are weird situations where a 485 randomly gets denied for completely wrong reasons. Sometimes it's, oh, we sent you an RFE and we didn't get the RFE, so we didn't respond to the RFE, and that leads to a denial. Or we scheduled you for an interview and the client rescheduled the interview, but then gets a denial saying you didn't attend the interview, even though they rescheduled it. Those kind of things do happen, but it's such a small percentage of the overall 485 filings that you really, again, have to weigh the risks, the risk of an H-1B denial or the risk of not getting an H-1B stamp by continuing the H-1B status versus the risk of maybe a 485 denial for some weird reason, if it's a clean case and there's no other issues. So I think for most people, they can successfully rely on the EAD and AP and forego that non-immigrant status. Right.
Medical leave on H1Bs, though. We have seen people who lose the job. They are requesting employers, can I be on medical leave? And we know what that medical leave is, okay? So they're trying to circumvent not having the pay stub. We strongly advise people not to do it. If you have an option of H4, please take the H4 option. If you have an otherwise go on to B2 visa. For you, it's available right now. You can. We are having many people who lost a job. Instead of going outside the country and looking for a job, they want to stay in the country and look for the job. Yes, you can be on a B2 and you can look for a job. That's a better option, but don't take the medical leave unless, if it is like a cancer, you have an accident where your leg is cut off and one leg is gone or hand is gone, then in those circumstances, that seems to be fine to me to take a medical leave. But the unnecessary medical leaves because you don't have a job is very dangerous for the employer, very dangerous for the employee in the long run, because they know that this is not a real medical leave and they may deny your extension of status, they may deny your change of status, and sometimes it may have a long-term impact on your immigration, where they may say that you are trying to deceive the immigration by submitting the fraudulent documents. So please stay away from this medical leave unless it is a real emergency for you.
All right, should we go to questions?
Chandra is asking, my parents are planning to visit and they are going for the visa. How much is the bank account he wants it to be? I mean, they're not that interested in that large bank account. Maybe $10,000 would be good enough. I don't think so. You need to have a large bank account.
Rajiv says, my wife arrived in the US last month on H4. Her I-94 expires October 20th. The visa stamp expires September 30th. Rajiv just got his H-1B extension approved till 2028, and he says, would you recommend to file the H-4 extension? So the I-94 controls, so she needs to do something before the I-94 end date, and that would either be travel and get a new visa stamp, which we would not recommend based on all the things we just talked about, or she can apply for the H-4 extension. So yes, she will need to apply for the H-4 extension, I-539 application before her I-94 expires. She needs to submit a copy of your H-1B extension approval notice, your last 3 pay statements to show that you're maintaining your status, along with her documents as well.
Question. How does the H4 people pay tax? Do they pay taxes similar to H1Bs or OPT? Monisha, it's going to be similar to the H1B, not OPTs. OPT people do not pay Social Security and certain other things, but the H4 people are considered to be residents of United States. They are supposed to pay taxes very similar to H1Bs.
Jagar says in August 2024, I was laid off, moved to the AOS EAD, working now. That company was closed a few months later due to going out of business. Will that impact my current 485? I-140 is approved. So, assuming that the I-485 was pending for at least 180 days at the time the company went out of business, it does not impact your 485. You qualify for AC-21. So that means that as long as your new job is in a same or similar occupational category compared to the job that you were originally sponsored for, you can move the green card process and continue it based on this new employment. The new employer may at some point be asked to submit a 485 supplement J. They need to understand that it is not sponsorship. All they are doing is confirming that they have offered you a job and the details of that job so that USCIS can determine whether it truly is similar to the occupation you were originally sponsored for.
Question is coming from Krishna Rao. He has the EB5485 EAD. Do you need to maintain the H1B or, he has a EAD and advanced parole? Now, there is something called I-526. That's the main thing. Is it approved? It's very similar to what Emily has said is about I-140. Not exactly the same, but it's very similar to that. If the I-526 not approved, which for most of the people, it will be pending until about before they get the green card, you should not be relying on the EAD or advanced parole of the EB5 EAD and advanced parole.
Hakeem says, can I apply for an H4 visa to join my spouse in the US while my H1B visa is undergoing administrative processing that's been going on for 2 years? Can you? Yes. Should you? Probably not, because your H4 is going to get stuck in the same administrative processing. We don't know what they're looking into with this administrative processing. For an H1B visa, you may want to consider litigation at this point, since you mentioned it has been 2 years. We have had success with that. If you want more information on it, you can reach out to Stephen Brown in our office. His email is stephen@rnlawgroup.com.
Right. Varun has concerned about two full-time jobs and GCEAD. You may want to have a consultation with an immigration lawyer who are experienced, Varun. It's not illegal to have two full-time jobs, as long as you're able to manage them. We don't see anything wrong in it on the GCEAD. That's an advantage of GCEAD.
Chandra says, my parents are planning to visit me. How much money do I need to keep in my bank account before they attend the interview? There is no amount for that. And really, the amount of money in your bank account is such a low priority for what the officer wants to see when your parents go for their visa interview. When they go for the interview, the officer wants to see that they are credible, that they're telling the truth, that the purpose of their trip to the US is in line with the B2 visitor visa, that they have specific plans, that they know where they're going to stay, who they're going to stay with, and that they're coming for a temporary short period of time, and that they will return at the end of the trip and they have a residence to return to, they have a job to return to, things like that. So having money in the bank is very low on the list. That is just to show that they won't become a public charge when they're in the US, that you'll be supporting them for their finances. But the interview is much going to be based on the interview itself. The decision is going to be based on the interview itself and how credible they are. The documents really are of secondary importance.
I'm expecting a baby in December 2025. I'm planning to take the baby to visit to India in July 2026. Do I need the stamping for the baby? I hope so not. Um, Emily, do we have any update on the birthright citizenship based on the knowledge right now? Everything is stuck in the Supreme Court right now. The Supreme Court hearing is somewhere in the end of October and may last all the way to November. And after that, we are expected to get decision. Can you correct me on that?
Yeah, as far as I know, there have been multiple injunctions that have been upheld at the appellate court level. And so it continues to be blocked for pretty much everyone nationwide. So there is no update beyond that, other than we're just waiting for a court to actually get to the merits of the case.
Now, there is an executive order that is passed by the Trump administration right now, but if the Supreme Court decision does come in their favor, if the children are born to the H1B or H4, they will be automatically being given a H4 within the United States. Very similar to that. So, yes, if by any chance a Supreme Court decision does not come in our favor, though, then you can take the child for stamping. Hopefully, I don't have to see that.
Roshan says, I'm planning to go for Dropbox for an F1 visa renewal. I'm in STEM OPT. What do you suggest me to do? What could be the risks? What are the chances that I need to do an interview? Um, as we said at the beginning, we do not recommend travel if you need visa stamping, even if you're going before September 2nd and can somehow qualify for Dropbox. When you are applying for an F1 visa stamp after you have graduated and you've already been graduated for at least a year since you've been in your STEM OPT, the purpose of your F1 is for you to go to school and study. You've already done all of that. It's going to become more difficult for you to convince the officer of your purpose of returning to the US. They may think that you are an intending immigrant because you've been here for a longer period of time. So there's lots of risks of denial. We saw all kinds of crazy things happening with CVIS terminations and revocations of visa. I mean, F1s are definitely a target. They've added this social media vetting. Do you really want to take that risk and lose out on the rest of your STEM OPT and then not have a chance to get back into the US? Unless there's something really, really important for this travel need, I think I would not travel.
Question is asked whether or not Ravi Kumar is asking, do you sell stamping in Canada or India? You're just asking me the question. I want to bang my head with a granite stone or a marble stone. I don't know the answer for it. It's either way. It's. I just can't say yes to either of those things. Rajendra Prasad is asking very interesting question. He is on 485 EAD. His wife is an EAD as a dependent. She is planning to open a dentist office on a 485 dependent EAD, and she wants to open a S corporation or C corporation. S corporation, absolutely S corporation, Rajendra. You can consult us, and these accountants, the CPAs, sometimes they get confused. Let me explain the difference between C corporation and S corporation. Now, I'm not good in numbers, but I am good in the subject, though. So C corporation, when it earns, let's say $100,000 income comes in, they have to pay $20,000 as an income and as an income tax, and your wife is going to get the $80,000 as a balance. Then your wife have to pay the personal income taxes on the $80,000. So that means that she's being taxed double. But if your wife opens a S corporation, she pays zero income taxes on the 100,000 for the corporate taxes. When it comes to her personal things, she will have to pay taxes on the 100,000 personal taxes, which is only one-time tax. So S corporation is good. Now, here comes the magic, though. When you go to the CPA says that only the residents of United States can be the owners of the S corporation, and your wife is not a resident because according to the CPA's reading, not our reading, according to the CPA's reading, the resident definition means green card because they look into the immigration definition. Because when you look into the immigration definition, the residents means green card holders. But they're wrong. They should not be looking into our regulations. They should be looking into the IRS regulations. IRS regulations are very clear. The adjustment of status EADs are considered to be the residents of United States, and thus by they are subject to the Social Security taxes. So they can open S corporation. Now, H1Bs, H4 EADs, L1s, L2s, they all can be partners in the S corporation, but not the F1 visas. The F1 visas cannot be partners of the S corporation. They can only be partners in the C corporation. In your wife's case, since she's on a 485 EAD, she can be the owner. Can she be 100% owner of S corporation? She's a dependent 485 on the. She's a dependent 485, so she does not have any restriction. She can be 100% owner. Absolutely not a problem.
Santh says, with a 485 pending in the EB1C category, is it possible to switch jobs in a similar capacity with a valid EAD? Are there any restrictions on the type of employer I can work for? No, the type of employer is not relevant. All that is relevant is the job itself, the job duties. Are they similar to what you were going to be doing for the EB1C company? So there's no requirement that the new company has to be a multinational company or that you ever worked for them abroad. So if your job title on the EB1C was vice president, and this new employer is able to offer you a job as vice president doing similar things, that should qualify for AC-21, as long as your 485 has been pending for 180 days.
Got an offer from dream employer looking to switch companies on H1B, concerned about NTS or NTS going down. I would say yes. Initially, when it got picked up as compared to right now, we haven't seen an increase in the notice to appear. But Jesus, if Jesus, if you got the job offer from your dream company, that's what you're telling, you can do one thing. I mean, you can have the company file a H1B, have them file in premium processing, get the H1B transferred in premium processing. Once it's approved, you can join. Thus, you will decrease the amount of chances of the NTA. So if I were you, I would take the offer right now without fear of the NTA. That's what I am now. Of course, there is always a chance. I will face it if I were you, because chances are very slim right now for that.
Lickett says, I'm on L1A, priority dates August 2023. I'm on my second extension, valid until December 2027. What is the other way, or any chances of the dates moving? Obviously, L1A has a max out of 7 years. So if you're not able to file the 485 and receive the EAD before you hit your 7-year limit, you may have to stop working, may have to exit the country. What else can you do? You can spend additional time outside the US and recapture that time later to extend your L1A further. You haven't reached the 7-year limit yet because you have this recapture time. We typically recommend our employers to put people like this in the H1B lottery, so that you can convert to H1B, which does allow you to extend beyond the 6-year limit. Those are pretty much your options.
I'm a green card. Question comes from Shilpa. I'm a green card holder planning to move to a new home. Do you need to do an AR11? Is online now? You can file an online AR11. We haven't seen anybody getting deported or having any problem if they didn't fill the AR11, but we strongly advise people to fill the AR11 form if you move from one address to another address. Now, some people say, hey, it's been like 3 years, I moved to a new address. Can I still do the AR11? Go ahead, do it. It's not going to harm you in any way.
Varun says, is there a concern with multiple full-time employers on a GCEAD?
Emily, I covered it.
Oh, you got that one already.
Anil has this question. I'm expecting a baby in December. Can I have a paid family leave? Yeah, if it's like 1 or 2 months, that seems to be reasonable. But if it extends beyond that, we definitely want you to look into alternative options of H4 or B2.
Sharon says, my wife is on H1B and is taking maternity leave. The company provides long-term disability insurance, which pays 60% of the pay for 2 months. How does this impact H1B status? Maternity leave generally does not. It is considered to be in H1B status as long as it is part of the company's approved maternity leave policy. And receiving the disability insurance in lieu of your normal pay is not a problem, as long as that's how the company normally does that with all of their workers.
Um, Jay has this question. He has a valid stamping until June 2027. He works full-time, planning to travel to India for 72 days. Any concern? Absolutely not. As long as you have the job and your job is still there, you don't have a problem. We have seen some posts by other immigration lawyers where it has been become a concern in our office, where they posted that since you are working in India, you need an LCA in India. That is all lies. First of all, there's no prevailing wage at all for India. Second, you are an Indian national. At least that's my understanding. Based on your visit for 72 days, I'm assuming that you are Indian national, Jay. If you're Indian national, for you to work in India, you don't need any work permit. I happen to have a license even though I didn't practice that much. I'm a lawyer in India. I'm a licensed lawyer in India. I can advise people who are working in India that yes, you can. Anybody can say that a citizen of that country can work in that country. Absolutely not a problem. No problem. And the rumors that the people have returned after 60 days, they're deported. That is an absolute lie. And you can come back after 60 days. The only thing is that when you come back into the country, you need to have that job. A lot of the people that we know about, when they spend a lot of time outside the country, they do the job in their home country and then come back and they continue the paycheck. In that case, we do not see any problem whatsoever at all.
Gayatri says spouses on L1B filed a change of status to H1B in June, have an approved I-140, but got an RFE about the 6-year limit, even though the I-140 was submitted. The I-140 was approved as a SDE Data 2, now promoted to Data Engineer 3. What are the approval chances? Since you mentioned it's an L1B to H1B, the L1B max out time is 5 years. Whereas the H1B is a 6-year limit. Now, if they used up all 5 years of L1B time, even though they have the I-140 approved, they are not able to switch to H1B. But if you did not use up all of the L1B time, then they are eligible to use the remainder of the L1B time to convert to H1B, use that I-140 to get an H1B that goes beyond the LH 6-year limit. No problems at all with that. Sometimes, especially lately, we see officers putting all kinds of crazy things in RFEs, claiming they know the law when they are not actually accurate. So it could just be that the officer is unaware of how that works, and everything should be fine if it's just explained.
Question come from Arun. His son born in California. Well, surprisingly, why people tell that. Yeah. And wife is, and of course, you guys don't have green cards. Is child considered to be U.S. citizen? Yes, according to us, yes, definitely. I want you to apply for the passport of the kid right now. I want you to apply for the birth certificate right now. Please make sure you get it. Now, can his citizenship be revoked at a later date? Now, here is the thing. Emily, please correct me on this one, Emily. Is that between February 19th and until now, everybody is considered to be U.S. citizen. And hopefully so until the Supreme Court gives a decision. So the Trump administration, they are arguing that from the time of February 19th, even though the court gave all the injunctions, they are arguing that these people should not be considered to be US citizens. That's what their argument will be. The Supreme Court is going to rule. Now, there are a lot of lawyers which disagree. I mean, we lawyers disagree on everything, every time. But what we don't disagree on is that the Supreme Court will make the final ruling, and that will be the final. That's what we all agree upon. So it will depend on Supreme Court ruling between February 19th and until the Supreme Court gives a decision. is what I'm thinking. But I'm 99% sure that the Supreme Court, when it gives a decision, though, it will only give a decision going forward from that time, not going back, only if the decision comes negative to us. Now, if the decision comes in our favor, we don't have to worry about at all in future. But if the decision comes negative to us, it should be only going forward. That is my belief, but it's only 99%, not 100%.
Yeah, I definitely agree with that. I mean, could you imagine the chaos that would be created if we get a decision from the Supreme Court in November 2025 and they claim that now all the people born between February and November are no longer citizens when they were during the injunction? These people probably have passports, they probably traveled. Um, how do you go and take back those passports and then convert them into some sort of non-immigrant status? I just don't see them doing that. I think that's very unlikely to be the case, so it should be going forward only.
Um, does the GC holders minor traffic interactions become an issue at CBP, like red light, toll violation? No, but you need to be very careful that when you get these, especially the red light violations and traffic violations, you need to take care of those things. There are some people that neglect them, and then there will be an arrest warrant issued, and then you are traveling without solving that problem. It may create a problem at the port of entry, though. So if you just have a red light, either you paid the fine or you contested in the court and got the case dismissed. Either way, it's fine. But if you neglect it, it may become a problem. This question is from Silicon Valley, for the Silicon Valley guy.
VA says, what are the odds of starting a startup and applying for an H-1B? How are the approvals? Already on H-1B, working for other employers for 14 years. Really haven't had any difficulties in getting H-1Bs approved for people who own the company that is sponsoring them, the entrepreneurial H-1B. It's only valid for 18 months, so we'll have to see 18 months from now what the extensions are like. But the initial approvals have been quite smooth. I don't even think I've seen an RFE on any of them yet. So far, so good.
For the people who are having the priority date in mid of 2015, yeah, it may take a couple of years for you guys to get the priority date current.
Tarun says, my wife is in India for medical treatment. Her H4 expires September 30th. Should she just go for stamping there or return before the 30th and then file the extension in the US? She can do either. I think part of it depends on what's going on with the medical treatment if travel is an option. It probably, as we've talked about, visa stamping going forward is going to be problematic for a lot of people just due to delays and potential 221Gs. So it would probably be best for her to return on her existing stamp and then file the extension and then remain in the US after that. But if she needs to keep being in India for medical treatment, then it doesn't really make sense for her to do all of that.
This question is, I'm going to address this question for a lot of different people that are asking this question. They have an EAD AP valid until 2029. Then they recently traveled on the advance parole. When they came back, the I-94 was only issued like DA, and it's only issued up to 1 year. Should they be concerned about, in this particular gentleman, Vishwanath Govindan's case, its I-94 expires in September 2025. No, you don't have to worry about it. This is only for advanced parole people I'm speaking, not for the H-1B people. Since you came back on advanced parole, they only give for a period of 1 year. So you should not be worried about, you are in adjustment of status, not a problem. Let's assume that you came in advanced parole and your H-1B is actually expiring in 2026 August, but your September 2025, your I-94 is expiring. When should you file the H-1B extension? This is only for the people who travel in advanced parole. You can file the H-1B extension if you want to before August 2026, not before September 2025.
Vamsi says my priority date is 2016, but I'm afraid that I might get a promotion in the future. Would it be advisable to wait until I get a promotion and then file? Um, I'm assuming the 485 or for the new labor certification because of with a new employer. So there are differing opinions on that. I would say most attorneys are of the opinion that a promotion that is part of a normal career progression is not going to negatively impact the already approved labor certification or I-140. So you shouldn't need to refile anything after the I-140 is approved and you then get promoted. I mean, we've got people who have priority dates in 2012, 2013 that are just now getting their green cards. I can guarantee not one of those people is in the same job that they were offered in 2012 when that labor certification was filed. And they're not going back and filing labor certification again and again every single time they've gotten a promotion.
Emily, what do you think about the Dignity Act? I did not even spend time because I don't think so. This is going to be passed in either lower house or the upper house at this point of time. Why waste my time? That's what I thought.
Yeah, I agree with that. I don't think it's going anywhere. I know there's people saying we might have a window for reform because there's so many people that don't like what's happening right now. But with the current makeup of the House and the Senate, I just don't see any possible way that it's going to move forward. I think we need to wait for the next midterm election and then might be able to get something passed after that.
Yeah, after the midterm election, the lower house, which is House of Representatives, will be flipped. The reason why we tell is that historically, from the time of Ronald Reagan, almost like long time ago. Most of you guys are not even born. Every president, when they do come in, the House of Representatives is in their party, but in the midterm, it flips, including Clinton, Obama, Bush, Biden, Trump administration previously, Clinton, and the senior Bush, the junior Bush, and senior Bush, all of them it flipped. So we do expect the same thing this time. Then the House might be still at that point of time. It's a very slight chance because the president is not in favor. But at this point of time, though, before the House flips, it has, I mean, I don't want to spend any time and energy on the Dignity Act at all.
Ash says, I'm in the H-1B grace period. Can I file a change of status to B2 for me and my wife myself, or should I apply through a lawyer? Are there any risks of filing myself? Totally up to your personal preference. A lot of people hire us to do that. A lot of people do it on their own. You can file online if you do it yourself versus if you file with a lawyer, you have to file it on paper. If you file it online, you have to pay double filing fees because you and your wife will have to file separate applications. If you file on paper, you can file together in one application with the I-539 Supplement A forms. You can save a little bit of money on filing fees. But you can always go online, start filling out the application, see if there's anything that trips you up or you're not sure how to answer, and then decide whether you want to proceed or not. But there's definitely plenty of people that file it on their own.
Emily, I get this interesting question though. There are some people who really want to pay the bond, especially for the parents who, and I know some people, I have like very good family friends, they're cousins, their brothers, their sisters got their visiting visa rejected, and they don't mind putting the bond of $15,000. I know them; they don't mind. And this question is coming here from Krishna Shetty. Can they do the bond of 15,000 right now for their parents?
I don't think so. I don't think there's a way to proactively do it. Is it possible that after the initial year, they will think that this is a great program and expand it to other countries? Possibly. So it might come in the future. But I don't think there's a way to do it
Do
right
it in the
now
next
unless you're,
in the next 1 year. You cannot,
yeah.
right? After that, you will have to watch our YouTube channel to see if things will come up.
Gayatri says, to file an H4, do we need to contact the employer's law firm or any law firm? Either one is fine, assuming you have a copy of the H-1B approval notice. That's really all you need from the employer's law firm, but you can choose your own law firm since you are the dependent. You're not tied to the company or a specific law firm.
Tanuja has this question. If POM has been approved, POM has been pending for analyst, and she got the NIW approved, is there any advantage for filing the employment-based the I-140 application when the POM gets approved? There may be some. The reason is that the NIW is considered to be in EB2, so not in EB3. So if you get an I-140, though, it may be transferred to EB3. So it becomes easier to transfer to EB3. So that's the only advantage that I can think about, Tanuja, for getting the I-140 approved by the employer. And you can give them the EB2 NIW. Now, when the lawyer sees the EB2 NIW, the lawyer will say, because he's representing the employer, hey, I don't want to spend all this money. You already have your I-140 approval. There is a possibility for it. But there is only one advantage for the perm-based labor I-140, that is EB3, because you cannot convert NIW into EB3.
Rami says, I entered the US on AP and got the I-94 for 1 year, but I have a valid H-1B until 2027. What is my current legal status? Is it AP or H-1? So even though you entered on the AP, if you have a valid H-1B and you go back to work for that same company under the same terms and conditions on your LCA, you can consider yourself to be in H-1B status and only extend your H-1B in 2027. That's the only time you can ignore the end date on the I-94 that's online, if you are relying instead on your H-1B I-94.
Abhishek is asking, do you expect the priority dates of EB1 to be moved? It's a very tough question. The EB1, the EB1s, there are a lot of people who are cutting the line. They're coming into position. So it's very hard to judge if it's going to move. My prediction is that if it may not move significantly. That's what, because there are a lot of people. First of all, there's a lot of inventory that is already there. And even after the inventory that is completed, though, there are a lot of people who are cutting the lines coming into, because those people who are in EB2 and EB3 converting into EB1. So they will cut their lines and come ahead of you, Abhishek. That's where the problem is coming. Is getting visitors visa new administration is more difficult or easiest based on your experience? I would say that the denial rates have gone a little bit higher on a visiting visa, but have they gone significantly higher? The answer is no.
Srikanth says, my H4 EAD is under processing. If we travel to India while it's pending, will that abandon the H4 EAD application? Assuming this is a standalone H4 EAD, no, it does not get abandoned. All that it requires is that you are in the country in H4 status on the day of filing. You can travel while it's pending.
Can an H-1B employee buy into the employer business? The simple answer is yes, you can. But however, if the same company is going to file the green card for you, though, it definitely will become a problem, because at that point of time, it has to go through a lot of scrutiny if the same company is going to file a POM application at a future date for you.
Blue Hammer 09 says, I'm on F1 STEM OPT, approved for H-1B this year with a change of status on October 1st, but I lost my job on August 1st. What are my options? Can I go back to F1? It's a very common issue that happens this time of year every year. And there are some difficulties with going back to F1 that students encounter every year. So the issue is that the CVIS record automatically knows that your H-1B has approved. And in many cases, it will terminate the record because your change of status is approved. You're on H1B. You don't need the F1 status anymore. So in order to get that data fix done for your CVIS record, most of the time, the school is going to ask you for proof that your H1B has been withdrawn. So your company that that you lost the job with, they would have to notify USCIS and request to withdraw the H1B. They can do that, but it can take months for USCIS to actually issue the confirmation of withdrawal. And that is what the SEVIS system needs. They're not going to do it on the basis of you just asking or the DSO asking or the fact that the company requested the withdrawal. They will wait until the withdrawal confirmation comes back from USCIS, and only then will they try to do that data fix. That could be months later, and you're in limbo that whole time. So for that reason, you may want to consider keeping your H1B, especially given how difficult it is to make it through the lottery. Because if you give up your H1B before October 1st, you're going to have to go through the lottery again at the end of your STEM OPT. Who knows if you'll get selected next time around. So with all of that, you may want to consider keeping the H1B. I have successfully argued that the H1B grace period begins on October 1st, even though you lost your job in August, and that you have until October 1st, November 1st, basically November 30th to file an H1B transfer to a new company. And I've done that every year around November and have never had an issue with doing that. So hopefully that would be an option again. But there's definitely difficulties of trying to get back to F1 status this time of year.
The Haley Drum has this question: since you're identifying fraud EB1s revoking their green cards, they're putting it in the next year, will it become more numbers? They're doing it, but the process is very slow for them to do it. They have to issue a notice of intent to revoke, and there is a lot of process there. They are doing it. But yeah, there will be some numbers that will be allocated, but there are still a lot of people that are coming in. We have seen a lot of people going to India, working on for 1 year for the company, especially some FANG companies are moving good number of people outside the country and bringing them back an EB1A category. So that's going to be very tough to compensate though. But yeah, some numbers are getting added because of that. The fraudulent EB1 is getting revoked. Alberic has this question. He's a naturalized US citizen. He's planning to visit Europe and Middle East for 2 weeks. Do you think he will have any problem returning to USA? Absolutely not. I don't think so. You will have any problem coming back into USA. You are a naturalized US citizen. You're perfectly okay to travel.
Dagish says, I have an EB2 NIW approved. If I go on F1 visa, can I apply for adjustment of status when my priority date becomes current? Very likely, yes. So in order to file the 485, you need to have entered lawfully and have maintained your status, in this case, F1 status from the time you entered. Even though the F1 is a non-immigrant intent visa, you have to document your intent or prove your intent at the time you apply for the visa at the consulate, at the time you apply to enter the US, or at the time you file an application for an F1 status with USCIS. Once you've done all of that, if you later want to file a 485, you can do that. No issues at all. You can keep your F1 status while your 485 is pending. You just can't travel on the F1 after you filed the 485. You would need the advanced parole to do that.
Satish is saying the priority date is October 15, 2005. He filed an EB1A in the normal processing. How much time it's taking for the Texas Service Center to adjudicate the application? Between 4 months to about 12 months is the time that it's taking. I don't understand why you don't file the premium processing. The concept that you file in premium processing, you get the denial is wrong. The concept that you get an RFE because you file the premium processing is wrong. Now, you will get the same thing faster though, compared to normal, because you paid money for the premium processing. They will give the RFE faster, they will give the approval faster, but we don't see statistically that premium processing gets more RFEs or denial. That is a wrong statement.
Well, I think we are out of time for today. Thanks everyone for joining us. We'll be back next Tuesday with the latest updates and again, taking your questions